This is the current federal tax developments for the week of July the 8th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. And this week, since we had a rather short week with the holiday in the middle of it, we're going to go and do a little bit different in our updates this week. What I'll be looking at this week is we're going to discuss a couple of end-of-term U.S. Supreme Court cases that likely will increase challenges and the likelihood of success of challenges various U.S. Treasury regulations. We'll talk about the overturning the concept of Chevron deference, explain what that is, why it was important, and what may be the impact of the changed provisions here. I want to kind of talk about all of that, as well as a later case that was in some ways a little bit more surprising, I think, to a lot of observers. I think almost everybody had thought that Chevron deference was going to bite the dust this term, but also a case that created an extended statute of limitations for challenging under the Administrative Procedures Act. That one was a little more surprising because it appears, and the court's opinion kind of mentions this, that a good number of circuits had ruled opposite of the U.S. Supreme Court. Only one had ruled apparently in the court's favor, the way the court ruled, but the court went with the Sixth Circuit. And so we'll talk about how that, extending the challenge time for the Administrative Procedures Act based upon 6 years from the date in which a particular taxpayer has a negative impact from the regulation in question, how that will make it a little bit easier to bring things up for challenge based on challenging regulation under Administrative Procedures Act grounds that it violates the APA. Okay, so let's get started this week. As I said, we're coming off the holiday week, and obviously there wasn't a whole lot going on last week. We technically only had one day that wasn't, part of the week. In reality, really, because everybody on vacation and gone, last week was pretty quiet, let's be honest. So we're going to talk, though, about a couple of cases here. And we're going to talk about these cases on regulations. And these two cases were decided right at the end of the Supreme Court's term. If you're not aware, the Supreme Court always starts their term the first Monday in October and generally looks to end the term in the June of the following year. So giving themselves July, August, September off, and then they go back and restart in October. So we're now at the end of the term. And traditionally, the Supreme Court holds some of its biggest cases for release at the end of the term. And I'm sure you heard coverage of some of those cases on other issues, right, last week. You probably didn't hear a lot of coverage on the tax issues, although some of this did get discussed. But we'll talk about it right now. Not so worried about the big cases. I'm not going to go through the presidential immunity case, any of that stuff. That's fine. You have your views on it. You have your ways you want to read it. But it's not really going to make much difference in taxes. These two, though, will make a difference in taxes. And we're going to talk about a pair of cases here. The first one is Loper Bright Enterprises versus Raimondo. And this one was the challenge to what's called Chevron deference. And this particular case will hold that basically the courts do not have to give absolute deference to agencies on interpretations of ambiguous statutes if certain criteria are met. Currently, we'll talk about what the Chevron, the Chevron's rule told the courts to do, and then talk a little bit about how we're going to change that somewhat. Now, it's a little more nuanced than a lot of people are reporting. We tend to get reports saying, oh, no, at this point, then, just totally ignore what the agency does. Don't pay any attention to it. Have a bunch of judges who have no clue how taxes work, have no clue any of this is. They're just out there in the blue, kind of winging it. And no, it's not quite there. But we will talk about it. And I don't want to get too much into the politics of it because, this is tied up in a lot of concepts. Rather, let's talk about what the court said and how the court has outlined a new standard that's going to be used. And that standard does not totally disregard agencies or even disregard agencies having special expertise the judge will not have in order to evaluate these regulations, but rather just make a difference in whether we are talking about a question of law or a question of fact. And generally, and this is oversimplifying, but we could say that there will still be great respect. They don't use the word deference anymore, but there will be great respect granted to an agency's expertise in areas of fact. right? Assuming they can present and prove that fact, that they did the work to back up the factual background. But the courts will not necessarily give deference in interpretation of law. There'll still be some cases, and there'll be some areas where that line is not so bright. But they would say that apparently a judge should have higher level of expertise in an area of law than arguably should, let's say, a chemist, from let's say the EPA. The chemists from the EPA may have a lot more expertise in the areas of the effects of these various chemicals, levels that are considered adequate, how they would disperse through the atmosphere and those issues. Your average judge most likely does not have a PhD in those areas. But that chemist probably doesn't also have a direct background in traditional statutory interpretation rules, so they're going to divide up a little bit that way. We're then going to look at a second case, which is going to be the case of Corner Post versus Federal Reserve. Now, this one does seem to have caught more commentators off guard that the court took the direction it did. But this looks at the statute of limitations for raising a challenge under the Administrative Procedures Act. This was an act that was passed, as I recall, in the middle of the last century. It was passed basically to try to limit the total discretion of agencies and come up with a standard process for agencies to develop rules, regulations. Again, under tax laws, we will call these final regulations. Under a lot of other agencies, we'll call them final rules. But basically, this is meant to standardize the practice, to force agencies to go through certain processes and force them to meet certain standards. This statute has like many statutes of this sort, would have a statute of limitations for how long one can wait before bringing an action in court to challenge the particular issue. And what will be a little surprising here is that while most circuits had previously ruled, that had ruled on the issue, had previously ruled that the 6-year statute, which is in the statute, not surprisingly, that statute began to run on the date a final rule was basically made final. The Supreme Court says, no. It looks at each plaintiff and starts the clock at 6 years from the date on which the plaintiff was first negatively impacted by the regulation in question, thus greatly expanding the time period the challenge could be mounted, because obviously, especially something like tax regulation, some regulation dealing with the taxation of long-term capital gains related to, raw land is only going to matter the first time after that reg is published that you actually sell raw land and have a long-term capital gain, right? So it would be 6 years from that date, not 6 years from the date that the IRS put out the first reg. So, if you've never been to oil and gas, in theory, you now have oil and gas income this year, and you want to challenge regulation on, leave it a little bit open here. Let's talk about maybe challenging regulation regarding percentage depletion. This will be the first year you'd ever have a right to claim it. In theory, you now have a 6-year statute to bring your APA complaint before the court. I have my doubts you're going to win it, but still, you would have more time. So the combination of these two do suggest that generally, I think anybody would have to agree that these two changes will make it easier to challenge regulation, but easier only in court. And I think that's important to understand. These both apply once I go to trial, right? And so I think we have to understand that if you're not willing to go to trial, you may have trouble actually making use of these provisions. And you may need to hope somebody else, tries your case for you. And while you still have the statute open for you to file claims for refund. We'll make that a little bit clear about these two cases. Okay. So yeah, more time, more likely to be overturned, right? We'll go down there. Let's talk about the end of Chevron deference. And this did get press coverage. So this again is Looper Bright Enterprises versus Raimondo, United States Supreme Court case numbers 22-451 and 22-1219. The decision was issued on June the 27th as part of this wind down process, right? Didn't quite make it out by the end of June. They ended up actually carrying over into July 1st was the final decisions ended up being read from the bench by the Supreme Court. But this one was not one of those, so we can go down that path. Now, this was not a tax case. It dealt with fishing rights, right, out into when the U.S. extended international waters out to the current 200-mile limit from the old, 12-mile limit, and then regulating fishing in those areas, and specifically dealt with a regulation that indicated whether or not whether or not the federal government had the right to impose a system in the various, and they break it up into districts too, so it's a little bit weird how it is. In the particular Northeast U.S. district, if they had the right to impose the cost of an observer, if your boat got picked to be one to have an observer on it to assure the rules are being followed, you could conceivably have to pay for the cost of that observer if the government itself didn't fund that observer. And this is the reg being challenged. And due to quirks in the law, there is a question about whether it truly could be authorized in that area, even though clearly in, I think it's the Pacific Northwest, there was little question that, yeah, it worked. It was allowed in the law. And it's, a whole long mess, none of which matters to us. We're going to resolve this issue from a tax side. We won't really care. Unless you're out there fishing, and I'm not talking about fishing with your pole, from a rowboat somewhere. I'm talking about out there with the big trawlers and stuff doing fishing. You won't mind these cases. And the court made it very clear. They weren't deciding whether these regs were truly over the bounds or not. All they were deciding was whether or not, in essence, it was appropriate for a court to decide this case based solely on the Chevron deference provision, right? Now, it's been pretty clear, and this is why it didn't surprise most observers, that the Supreme Court over time had been basically chipping away at Chevron, creating a number of special cases or working its way around or, kind of avoiding applying Chevron to various cases. So Chevron certainly had gotten much weaker in recent years and certainly much weaker, let's say, over the past 4 or 5 years as the makeup of the court has shifted. So basically, it wasn't too surprising. Now, one interesting place in tax we're going to look at this is in 2010, the Supreme Court handed down a pretty significant case called the Mayo Foundation for Medical Education and Research versus United States. And that case did cite Chevron, but also found a delegation of the right to set the regs, legislated in essence by Congress to the IRS at 7805A. And this could get interesting trying to figure out how this opinion would interact with Mayo, because what the opinion will tell us is, of course, well, Chevron doesn't control, but it also states that if Congress has actually delegated legislative authority, then basically, it's a different beast than if Congress is merely taking a piece of legislation where there was no clear delegation to the agency to write in the area, and then issuing interpretations there. And it's not clear. I mean, Mayo is a case, the more you read it, the more you go back and check against this particular case, the more confused you get about whether Mayo is, kind of like irrelevant at this point, or if Mayo is somehow now, oh, no, it doesn't matter. This case is irrelevant because there's been a delegation. And what I find real interesting is Chief Justice Roberts wrote both decisions. So yeah, it's kind of interesting trying to reconcile the two. And it may tell me more about how you feel about Chevron deference when you tell me whether it invalidates the case or doesn't, because I think it can be read either way. Just saying, I think Mayo can be read either way, because I think there's magic words in there for a delegation, but also it seems to be in the context of, Chevron. Well, yeah, we get into that whole mess as to where we are, right? Okay. Now, let's talk a brief second now about what was Chevron deference, right? It's important because if you ever heard me to talk about how regs are evaluated by the courts, and this is following Mayo, same basic difference though, but following Mayo or following other issues. We talk about how the courts basically interpret whether a regulation issued by the Treasury is valid. You're going to challenge its validity. Generally, it required a two-pronged test. And I will tell you that this case will not overturn the first prong, right? Everybody agrees it's the second prong of Chevron that people got more worked up about, not the first. So what it says first it says, does the code itself unambiguously address the issue in front of us and unambiguously give an answer to that as to how to treat it? If that is true, if it is unambiguous, the answer, the code just very clearly tells us what we have to do, then essentially, and the regulation does not follow that direction in the code, the regulation is invalid. In essence, kind of saying that if it's that clear in the code, you really don't even need a reg. The code tells you do this, you do this. That is the issue. For instance, I would probably argue that, let's say, subject to the mechanical calculation of the inflation adjustment each year, the base rates, well, let's say, in fact, the brackets are what move. The rates don't. The actual tax rates in the code, you're going to need a regulation to tell us, say, 20% capital gain rate is 20%, right? There's no ambiguity of what 20% is. There might be ambiguity about what the income is we apply the 20% to, but the 20% itself is not ambiguous. That's totally unambiguous. And if a regulation said, oh, no, the rate's 17% or the rate's 27%, that would not be a valid regulation. And that isn't going to change after this. But the second prong was more interesting. If there is ambiguity in the law, Congress wrote a law that is capable of multiple interpretations, at least more than one. There's more than one way you could read it and interpret the reg, right? Then all we ask when faced with a Treasury regulation is that has come through the APA. Is a Treasury regulation a reasonable interpretation of the law? If that interpretation of Treasury is reasonable, right? In essence, it means it appears it is a reasonable way to read the law, right? It is one of the possible interpretations out there, right? And it's not unused, stretched wildly, and Treasury didn't violate the APA by failing to get comments or respond to them or any of those things. If that's true, and it's a reasonable interpretation, then the interpretation will be upheld even if the court itself believes that there is a better interpretation of the law, right? So so the court's not allowed to use standard statutory interpretation techniques against the statute. At least once we got to the point past saying it's not absolutely clear, that they could not use those techniques to decide what the proper application of the law is, so long as there was a reg out there. Now, if no reg has been issued, we often have that, like right now, there are no regulations issued on the question for the employee retention tax credit. And those definitions, there are no formal regs because by the time regs got approved, wouldn't be relevant anymore. Basically the way it works. But in that case, if there's going to be a challenge on the ERC issues, then the courts are definitely going to be using the standard, reasonable interpretations, using standard statutory interpretive techniques to determine, what is the proper interpretation of these provisions, like what is a partial, we talk about, the partial suspension of a business under the ERC rules. What does that mean? And that would be using standard statutory interpretations to determine about how that works out. Once we've gotten to the decision, maybe, what is considered a partial suspension is not a completely unambiguous statement, right? Then the court had to figure out what is the most proper interpretation of that. And that doesn't mean everything goes, right? It just means, is there a more proper interpretation? Because what will happen in court is presumably the IRS will show up with one, the taxpayer who claimed ERC will show up in another, and the court will evaluate those two, but they can even consider whether a third, option 3 is a better option for interpreting it than either what Treasury came forth with or you came forth with as the taxpayer, right? Those are the backgrounds. So this is called Chevron deference. It means if we had regs, then we just look to see if they were reasonable under the law. And if they were, we don't care, some other interpretation you like, and you might even argue is better. You have to show the IRS's interpretation was unreasonable. Okay. Now, as I said, these cases involve fishing rights, where the court had decided the case based solely on reliance on Chevron deference for these rules issued related to this offshore fishing, paying for observers situation. And so courts had ruled, and there were, I believe, 2 cases, that's why there are 2 case numbers, where there had been in separate courts had ruled based solely on the fact that, yes, we understand, we've got your evidence, but we're going to apply it solely based on Chevron deference. We agree the law is ambiguous, But we then decide that, in fact, the interpretation of the law by the regulatory body was reasonable, and we don't have to inquire about whether it would have been the interpretation we, the court, would have arrived at had we applied the standard rules or had there been no regulation. Right? That's the whole point here. Right? So they found the statute was ambiguous, right? Could we work with it? And we conclude that in applying the charges to the boat owners, if that was a reasonable interpretation of the statute, then it was automatically valid under Chevron, even if the court might have decided in the absence of any regulations that this was not, the interpretation the court would have arrived at. And so that's what we're trying to decide, right? In essence, not considering the best interpretation of the law using standard statutory construction techniques. That's what worked here, because the IRS, or not IRS in this case, the government interpretation was considered to be reasonable, right? So now we have to say, is that right? Is that the end of the inquiry? So long as the government interpretation is reasonable, it's going to succeed. Or should the court continue on and consider whether there is a better interpretation of the law, giving proper respect to the agency's expertise on facts, but also understanding we have to apply the rules of law to this concept? So we're going to talk about that at this point. Now, the majority opinion, it was a 6-2 opinion, and I believe it was Justice Jackson that basically didn't fully participate because I believe she was Solicitor General at the time that one of these cases made its way through the court. She'd been involved in the case. That's Solicitor General's job, as the current one said in the Moore case, when asked about something, was well, it's kind of my job to defend whatever the government's doing. Right? Because she was being asked whether, would you get up here and argue before us that a wealth tax was constitutional? And I thought it was a great response that she had at the time. She said, well, it's kind of my job to defend whatever position, the government currently has. So, she said, I'd probably argue it, but it's not relevant in this case, whether that's a good or bad interpretation. And so for this case, I take no position until I see what I'm supposed to be defending. Which I thought was a great way of looking at it. It was kind of interesting. It was amusing. Courts are in charge of the proper interpretation of legal issues. This is what the majority said, right? The six justices that signed off on this opinion said essentially that was the courts are in charge of proper interpretation of legal issues. As such, to the extent we are looking at interpreting the language of a statute, as opposed to applying facts to a statute, then the language of the statute is for legal interpretations, and the court should not defer on that to the executive branch. Right? Now, they said the agency's position is deserving of respect, assuming there's a reasonable amount of evidence behind it. But it's much more persuasive on the factual side than it is necessarily going to be on the legal side, right? In essence, that we're going to consider that, but we're going to pay a lot more attention to them on the factual determinations than we are on what the law, how the law should be read, right? The court is and in either event, because we are giving respect does not mean that the court is required to side with the agency in the determination that's been made, right? And even if it's a reasonable interpretation of the law, the court does not have to side with the agency if the court believes that a proper decision, applying statutory interpretive rules, would end up being more appropriate. There'd be a different one the court would have arrived at, because that, too, in the view of the 6 justices on the majority, is essentially a court, basically walking away from its responsibility to be the party to interpret the law, and its expertise in law interpretation. That's our area, and how deadly these chemicals are. That's your area, agency. Not, that's the difference in the world, right? So the court is to apply standard methods of statutory interpretation to the law. Okay. Now, like we said, they did say, and so the case goes on, and this is where it gets a little messier again. They did go ahead and say, well, that can extend to legal issues that are impacted by the agency's special expertise, but then said, but not all legal issues benefit from their subject matter expertise. Now, Justice Roberts didn't give us a nice, clean line to divide this with, which normally is what makes these cases so much fun in the future, because you're going to now have individual judges having, deciding where the dividing lines are. And yeah, that's when things get a little more interesting there, right? But it's there. Very clear, though, that the agencies will receive more respect, and even seem to grudgingly admit that, yeah, you know what? Going to law school, passing the bar, getting on, in essence, being confirmed to the court does not give you special expertise on the toxicity of various chemicals. Right? That's not really your bailiwick, right? That's not your area. Rather, in essence, so you might need to give there, or you at least have to understand that experts, the agency is going to provide guidance, and you'll deal with the expertise involved, trying to figure out which way we're going on that expertise, factual issues. They also argued that Chevron did not provide uniformity and predictability for the application of law. One of the key arguments in defense of the government and the dissent is that if you don't have Chevron, you have chaos, right? And yeah, you're going to find that the dissent and the main opinion, that's what they're tussling over, right? In essence, if they're, and to a certain extent, the main opinion almost comes down and says, well, maybe consistency is overrated, is one of those structures, looking at it that way. But nevertheless, obviously, it's pretty clear that, yes, we may end up with, obviously the judge in the courtroom applying standard statutory construction rules, which aren't really written down. I mean, there are certainly textbooks and things that will describe them, but they're not totally written down as to what they are. That will lead to the proper decision. And, the theory of this is, in this case, that Chevron prevents the proper decision from being raised. We're going to do this because this will be the proper decision using the proper tools. And yeah, it gets a nice argument there because, of course, as you might suspect, the dissent says, well, that's garbage because that we're going to get to different decisions. Why are there 9 people on this court? It's a kind of obvious thing. If the obvious proper statutory construction is that clear and all attorneys agree on it, everybody in this area, because that's our area of expertise, why does it take 9 of us? Why are there 9 of us on this court, and why do we issue split decisions? So, I mean, it's interesting both ways. So it's kind of one of those odd things you look at. Okay. Now, they also said that stare decisis is not adequate to save Chevron in the majority rules. They believe the original case was poorly decided and was not useful. And this is where they're going to spend a lot of time discussing the fact that it's led to inconsistent decisions, specialized stuff, courts essentially dodge around it. And there's been various things, including the Supreme Court has dodged around it. So, there are various issues there. Now, the interesting part is, stare decisis, which is that, you have to give extra, let's say, you have to be very, very careful about overturning prior law, right? Because people rely on that law. And, the one catch I find, though, is that, well, everybody will claim to be for stare decisis, right? It's always kind of right until you hit the thing they don't agree with. And then they'll want to change it. And I don't find very often, especially when you're in the Supreme Court, you make these changes where they're likely to go with stare decisis as a reason for keeping things as they are, as opposed to, just saying, nah, we're going to rewrite it because it was poorly decided. And we know it's poorly decided because I don't like the decision. Not quite that cynical, but somewhere close. I don't remember. I think the most likely case I could think of in tax that was arguably decided on stare decisis, even though the court believed that, in fact, that basically, the prior cases really weren't right, is Quill. right? If you read the Quill decision on sales taxes, which of course was eventually overturned when we got to the Wayfair case, you'll find that they really decided in Quill virtually that National Bellahas was probably decided wrongly, that looked at physical presence for taxing for sales taxes. But because everybody was kind of used to it, we're just going to go ahead and keep applying it. And Congress can come up with some fix for this because, that is something which all the decisions there agree that Congress could write rules for when sales tax has to be collected at the state and local level by out-of-state sellers. But Congress hadn't gone there. So, yeah, it was kind of interesting there. That one was a stare decisis case in many ways. It was the history is the reason why we kept it. And, of course, as you may become aware, in Wayfair, they decided, now we're past that now. So we're just going to go ahead and undo it. That'll be our key. But they do make clear here, so the mere fact that a precedential case on an area that has upheld a regulation is not immediately null and void, right? And should be treated as if it's not there, merely because it decided based on Chevron. Now, that though clearly means that you can argue the same way and say, okay, but since it was poorly decided, we could bring a new challenge. I don't think anything stops that. But it does say don't automatically argue that you now have things on your side because the only cases against you were all Chevron decided. This means there may need to be a further inquiry into what's going on. Now, for tax impacts related to tax, this will be the main concern of those of us here. It's easier to challenge an IRS regulation in court, but it only helps if you can truly afford to take the IRS to court. I think that's important to understand. You can raise Chevron deference arguments all you want. The agent in the office with you is going to follow the reg. And it's not very likely that the appellate conferee is going to ignore the reg, right? I think counsel is going to have to get involved before anybody's going to say ignore the reg. Right? That's it. Especially if the reg has not yet been challenged by anybody and no court's held it invalid, you are probably going to not get very far by saying, but see, the Supreme Court decided here in this case, so in Loper, whatever, that basically, hey, Chevron deference doesn't exist. It's like, great, doesn't matter. We still think our reg is correct. We believe it is the proper interpretation of law. So, yeah, you have to understand it's not going to be much administratively necessary. Right? The agents are not going to accept the challenge. I don't expect appeals to accept the challenge. I mean, I think they've got to believe you're going to file, not only going to file, probably have filed in court. And, and plan to take it to trial and plan to push. Right? At that point, they could be there. Now, the flip side of this, though, is if you have a large enough amount in question, the client has the resources, and therefore it makes economic sense. If I have a case where the total tax in question is $14,000, the IRS probably will believe I won't take it to court unless there are other unusual circumstances. And yes, this is a reference to the Moore case. And Moore had some special circumstances and the reasons why the case went to court. As I said for quite a while and said on this recently, Moore is a case all about the 965 tax, but in reality has nothing to do with it. Right. It was just the vehicle to get a question from the court that certain people wanted answered. And then the court kind of refused to answer the questions. But if you read the dissents and the concurrences, you might have gotten your answer. I will phrase it that way, is what I would say about Moore. But the same thing here. So, if you're a client, it would end up costing your client $15,000 to, basically, if this, because you have to apply the reg the way it's written, and you think it's wrong. Well, you're probably not going to get very far trying to say the reg's wrong, because the IRS is not going to believe that there's any way you're taking this to court. And unless you have some special situation like Moore did, I think most likely the IRS will simply disallow and say, take us to court. And if you do take them to court, and it's not the tax court, then they also may not care too much, right? The problem is the IRS's biggest concern here is that regulation gets pulled into the courts gets to a high enough level that it's going to be impossible for them to ignore it. Now, in the tax court, that could be any case, that's not a summary case, summary tax court case, summary opinion case, because, if this is the first decision the IRS has had, or the tax court has had on the validity of this regulation, very likely this will become a published tax court decision, and that would have national precedence. Any case goes to tax court. If the tax court has said the reg is invalid, well, now the service has a problem. And the only choice the service has is they could appeal the case. But even then, if the Ninth Circuit overturned and said, no, that regulation is valid, that's great for the IRS in the Ninth Circuit, but says nothing about all the other circuits. And at least initially, the tax court will still take a position the reg's invalid everywhere except the Ninth Circuit if this case was only appealable to the Ninth Circuit. That's the way that this math works. So my guess is we're probably going to see the IRS be very judicious. If your client does have the money to challenge, you may discover that the IRS is going to want to settle this case before it goes to court if there is a realistic chance they could lose it. This is my own bet on how things will work. We've already seen the IRS pull this off last year in the Jarrett case, a district court case in Tennessee where the IRS avoided trial on the question of whether staking income was or was not taxable by essentially just paying up the refund and not allowing the taxpayer their day in court to argue that basically staking income is not taxable in the Internal Revenue Code and shouldn't be taxable. Now, they just paid it up because then there was no court decision that could be cited anywhere else. And the Sixth Circuit, both the Tennessee District Court that, said, nope, sorry, your case is dismissed. Their argument is there is no dispute in front of us anymore. You sued because all you could sue for was your money back, which in this case was a couple $100, made the $14,000 look like a huge amount of money. And they've already agreed to pay you back, your couple $100. So there is no more case to be tried. And the Sixth Circuit agreed. They paid up for you, right? And the only thing you can do as a taxpayer is sue for money, and they've given you the money. I have nothing. There is no unfixed harm to you that I have a remedy to grant, right? My remedy is to pay you the money. That's what's allowed under the law. I can pay you the money. And, the IRS already paid you the money. So, sorry, no standing. I would expect to see I expect that we may hear about some cases that are handled in the Jarrett fashion, where they just refuse to let it go to court, right? It is their choice. And so, if they settle it, that's fine. Now, if your client has the claim, and I got no problem with that. My client, let's say, let's talk about a claim that's clearly going to be worth the money to go to court. Let's say my client has a $15 million claim here. And I think there's a really good chance the and not you better get legal counsel and constitutional counsel to really help you too. But let's say counsel has determined that there is a really good chance that reg will be viewed invalid based upon a number of other, holdings of the courts in this area, of, let's say, the Ninth Circuit, if you're in Arizona. My guess is that, when we come in, we make it clear that we are going to fight this. If the IRS wants to disallow that, that's great, but we're going to take it to court. You may very well find they get way more cooperative. And if not at the appeals level, then almost certainly the minute you file a tax court petition, when it goes back to appeals at that point, suddenly everybody may get a lot more cooperative. That's the way the U.S. legal system works. Let's be honest. If you have the money to get to court, and it's enough, and it makes sense, then at that point, we're going to get a full trial, and that's when you may find the other side decides we don't want to waste money on this case, especially in a situation like this where if we lose, it may set a precedent that will cost us a lot more in other cases. Be much nicer to pay out this $15 million, but then collect billions, in much smaller increments from a lot of other people, because we didn't let this case go to all the way up and say, hey, the regulation is invalid. Okay. Now, Chevron only affects regulations. So I've seen some speculation, which makes some sense because the IRS is already leaning this way pretty hard already, that the IRS may lean harder on unofficial guidance. They may publish things on their website, make announcements, make notices, and all those things that are sub-regulatory and even just not even really reviewed, not even in the IRB. But they're going to get more informal, so they'll let you know what you're almost certainly going to run into on exam. But they won't actually go the formal reg route, assuming that the reg doesn't get them much more, be their theory, especially if this would go the way that some people, might be thinking, oh, well, the regs are already wrong. Everything should just be, we're just going to go in court and every judge will make a judgment based only on whether or not, the regulation is in line with what the judge would have written had they been writing the reg. In that case, it'll just be more the IRS go with unofficial guidance, and we would go that route. So may see fewer regs. That's good news or bad news. My own take is that's generally going to be bad news if it happens, because I would much prefer the whole comment period, proposed regs, discussions, etc., rather than just having IRS by fiat. And I got to tell my clients, most of whom are going to have an issue that is not going to make sense to litigate. Let's face it, your clients probably 99% of the issues, even on your high net worth clients, would not be worth litigating. If the IRS disallows, a deduction and it'll be $20,000 of tax, you're going to burn that 20 grand up pretty quick litigating. So we're kind of in that background. And since the correct answer seems unclear to judges, like I said, I just referenced the fact we got split decisions here, right? So obviously the correct answer to this statute, right, looking at the statutes as they exist, the correct answer based on the statutes, Constitution, etc., obviously we got, 8 very well-trained, well-educated, highly experienced attorneys, right, who've had a lot of background in litigation, generally, before they get on the Supreme Court. If they can't agree on the proper interpretation of this, do I think there'll be a lot of variety at the district court level? Yes. I would expect the district court, the tax court, etc. Now, the tax court can always move it to reported, and that could bring the decisions a little more in line there. But district court cases, they're heard by whatever judge is assigned to the case. And as we all kind of know, if you've ever been around, done a lot of district court researching, and I know that we all kind of cringe if the only case you can find on your side is a district court case, because that those have a way bigger chance of getting overturned on appeal when they're in the area of tax, because, a lot of the district court judges aren't the most up to speed on tax issues. And they'll issue opinions that are like, that's going to fall on appeal, no question. Right? So, we may have a lot more differentials there. So be careful in that regard. Again, for the tax court, I do think there you're going to get more of a, the very nature of the tax court, the ability to go to published decisions, right? And basically bring it up for the entire tax court to vote on. That may very well serve as a good role there, where this could work much closer to the majority's view in the tax court, I would happen to believe. It'll be a little more interesting because at district court, I expect chaos. That's kind of the natural state of district court cases on tax anyway. Yes, and I got to double check. Yes, I don't have any clients currently suing in district court for a refund, so good. I think I can say that fairly safely now. But, so there would be more interesting, but a tax court, I think there's enough controls that probably it'll work better there. We also need to see, and remember, while the Supreme Court puts out this big pronouncement, we're going to find almost certainly the actual, basically hard and fast, what's going to be considered adequate respect test is going to be basically beaten out by the various courts of appeals. And what I think we're going to see is kind of a coalescing from the courts of appeals around certain ways of proper respect. What's proper respect under the Supreme Court holding and what's not proper respect. Again, the court does not do at the Supreme Court level. They talk in broad terms. And this is kind of like the whole problem we have when Congress writes broad laws, which caused this issue to begin with. Supreme Court writes these broad rules, and it's up to the various individual courts. And then the courts of appeal, because they're ultimately where, disputes get raised, and the courts of appeals have the right to bind all the courts under them, where we're going to actually see this worked out. So keep your eyes on to see how that develops is what the respect test means. Okay. Now, the other case later came out was Corner Post, Inc. versus Federal Reserve, the Supreme Court case 22-1008. And this came up July 1st. This was on the last day of the session, right? Under the Basic Administrative Procedures Act, which is that act that controls how one issues regs and what the steps have to be taken, how it should be done, a challenge under that act that they failed to properly follow the act can be brought up to 6 years after the right of action first accrues. Okay? The meaning of that term and who it applies to and how we start the clock and whether we start one clock or a clock for every potential plaintiff in the nation is what we're going to have to interpret under this law. Now, 6 circuits held that if it is a facial challenge, you're saying just flat out, the regulation is overall on its face erroneous and should be thrown out. They say those challenges to regulation, a right of access accrues on the date that the regulation is published, and the 6 years starts from there. Okay? There have been 7 circuits that have decided this issue. 6 of them have decided that when they publish it, you want to just challenge the statute or the reg as being invalid on its face. That's a 6-year statute from date of publication. The 6th Circuit said, nope, it is a 6-year statute from the date in which someone is injured. So there's a party injured. And that the statute starts separately for each party. So my 6-year statute could be different than your 6-year statute, right? Everybody would have a different 6-year statute based upon when they are first injured by this regulation. So as I said, if the regulation was something about, the computations of or timings of gains on sale of land, well, I haven't sold any land recently. So let's say I've not sold land, since that regulation came out. So it would still be open until the date I finally sell a piece of land. At which point then I could be injured by the regulation, and that would give me a 6-year statute to challenge and say, hey, they didn't properly follow the Administrative Procedures Act, and because of that, the regulation needs to be thrown out, right? They need to start over. That's the APA challenge. Now, again, the 6th Circuit had been the one that said, nope, even if it's a facial challenge to the reg, it doesn't start until somebody's injured. And that's going to be each plaintiff will therefore have their own statute, right, based on when they were first injured. Now, the Supreme Court notes under the law, the party, what they're saying is, they're saying, well, okay, the right of action first accrues. The Supreme Court says, so let's say me, I could not bring an action against the agency for violating the APA and harming me until I'm harmed. They're saying because you couldn't sue that until you were harmed, an injury was occurred to you, that means by the terms of the statute, every plaintiff has their own 6-year statute. And because it doesn't make, the statute itself says nothing about facial versus other challenges to the regulation, that there is no such distinction in the statute either, right? You basically, everybody has 6 years from the time the first harm occurs to them, which under tax law would probably mean the time you first actually do something that would have a tax consequence off of what the regulation says, and then you have 6 years to make that challenge. And that, that reg could have been published before you were born. But it didn't first harm you until you sold that piece of land. Okay? So it would open up challenges under the APA, which is not the only way a regulation is challenged, but it is a major way the courts have been throwing out regulations recently, or throwing out other structures that are similar. If you remember about where the IRS got the problem they're facing, where we have where you have basically conservation easements were part of it, but it was really about whether or not something's a listed transaction. Can they just put it on the IRS website and issue a notice on it? Is that good enough? And the court said, nope, that violates the APA, right? So we've had a lot of APA challenges here. So, it's basically, it's a powerful tool for challenging regs. It's one of the most powerful tools, for successfully challenging regs, because again, that one, I will say part of the advantage of that one was it kind of bypassed Chevron deference, because to a large degree, you went after, they didn't take comments into a place, didn't properly respond to the comments, the various ways you tend to blow up an APA. In the case of the listed transaction, they're just saying they didn't go through the proper hearings here because IRS didn't believe they had to publish a reg to do it. Now they're saying, yeah, you really do have to publish a reg to do it. Now, the government argued, like I said, the claim accrues when those regulations are published. So 6 years from the date the APA claim, 6 years from that date of publication, the claim would be off limits. And, they would kind of argue that was everyone, and seemed to even argue that even if it wasn't a facial challenge, it still would be the 6-year statute would apply. The government said, we need to know that these are for certain good. Everybody has 6 years to challenge it. And at least some taxpayers would be able to challenge during that 6-year period. So, hey, it should be good enough. But Supreme Court said, no, guys, a right of action accrues when the plaintiff has a complete and present cause of action. That is a right to bring suit. And nothing in here suggests that as long as a single plaintiff does, that the law, that basically you only have 6 years to bring it. And they also point out Congress has written statutes that would specifically state as 6 years from date of publication, right? That is the date on which you could file the claim. Basically, you have to challenge it within that 6-year period and present various rights. And here they didn't. Here they just left it open under the standard claim of right to bring suit. And they said, under the standard definition, that doesn't accrue until there is a damage claim. You are damaged in some ways, and then you have 6 years to bring the suit. Okay? So that, noting, there has to be an injury. The law requires, the law in its text requires there be an injury, right? So an actual injury, not when the cause that may lead to the injury takes place. They said that that's not supported in, basically any standard law. It doesn't support. By default, the injury, the mere fact I did something, it's like, let's say it's like, an attractive nuisance theory, right? You have a backyard pool. Let's say you don't build fences around it, you don't do other things around it. And, a child falls in and is injured. The old theory of attractive nuisance means that you could be sued, but it's not like you can be sued. The statute of limitations does not accrue the day you built the pool, but rather the day 20 years from now when the kid first falls in it. That's when you start your statute running. Theory is going to be that in this case, same issue. 20 years later, you finally run afoul of that reg, and that's when the statute begins. The injury test for cause of action is a standard rule. There's no indication Congress intended a different interpretation. And they know how to write earlier start dates. So it's not as if Congress, didn't know how to do it, and that the ambiguity should be read to mean, Congress obviously meant this, because they could have written it the other way. There was no reason to believe that they didn't know what they were doing when they wrote it that way. And they also went after said, and it doesn't matter that there probably were people who were immediately affected, because this case involved the case of debit card fees, being charged to merchants, the interchange fees charged to merchants for accepting debit cards, and federal regulations under that. In this case, a entity in North Dakota that had just recently begun business. These regs go back way before they existed. That they were suing, claiming that these regs were invalid, that in essence they were allowing for fees that were greater than the law allowed, so they had impermissibly, been written, and it was thrown out saying, no, the 6-year statute is gone. Sorry, guys, But wait, we weren't around at that point. We couldn't have sued. Well, tough luck. Court said, no, that's not right. In essence. Right? It doesn't matter that the other people, that nobody else at a convenience store, whether in North Dakota or not, could have filed a case for years. And I'm sure, convenience stores taking debit cards for a long time. Doesn't matter that they didn't file during the 6-year statute. That shouldn't cause you to lose the right to raise the challenge when you are damaged. It also says we don't want to give certainty. And this goes back to the same sort of stare decisis type idea. That, if you leave it open like this, and it could be challenged anytime, decades in the future, then, that means everything's uncertain, and people that relied on the law are disadvantaged, right? Because their statute for a refund of that stuff probably does go away, we don't know the reg is valid or not. We never can get finalized there. Administrative convenience does not override the clear wording of the statute. He said it's pretty clear it's allowing these rules, these things. We don't get rid of those just because it'd be inconvenient. And if Congress wants to change this, they can change it. Right? This one pretty much they made clear that Congress could change this one. It's not as clear Congress could change Chevron deference. But it is pretty clear that Congress could change this rule if they wanted to. So if they don't like this, Congress go change the rule. You could write it in such a way as to change this rule. Now, the impact on tax, it would impact the taxpayers to challenge the regulations for failure to properly follow the APA, along with other existing options. When they're first damaged by it, there are other ways to do it. It would be easier, therefore, to bring challenges to those regulations because certainly among courts recently, APA challenges have been much more likely to bring them down than other things. So that seems like it's there. And with the repeal of Chevron, it could bring certain regulations back before the courts. I think we're going to see a couple of prongs of attack on those. This and the Chevron rule would open up both. The immediate impact is likely limited until and unless your client's willing to litigate. Same problems with Chevron. If you're not willing to take them to court, not like going to do anything, because this whole thing is all about court cases. Again, the key difference is lower court between respect and deference for regulations. And with increased activity by the courts and using APA issues to invalidate guidance, counterpost may end up being the more significant of these two cases. That's possible. Okay, this has been the Current Federal Tax Developments for the week of July the 8th, 2024. Current Federal Tax Developments, as always, is brought to you by Kaplan Financial Education and by your state society of CPAs. I'm Ed Zollers again here. I'm coming again from Phoenix. Nice, really, really warm and toasty Phoenix, Arizona. Right? We're here this week. Now, if you have any questions, you can email me, edzollers@currentfortaxdevelopments.com. I also do answer, read and follow up to some questions on the Connect boards run by certain state societies I'm a member of. So Arizona, New Jersey, Minnesota, Illinois. I check those. Idaho, I check as well. If you have them there, you can post questions there. Otherwise, hopefully you're having a good summer. Not quite as hot as it is here, hopefully. And in any event, we'll see you back here next week for more current federal tax developments.